started with what is acceptance, right? We looked on to what are the essentials of valid acceptance. It must be communicated to the offerer. We looked at a case, and then it must be a response to the offer. It must be made within a reasonable time. It must be made before the offer lapses or revoked. It cannot be made through silence. It must be prescribed in the prescribed manner or a reasonable mode. These are the 6 essentials of acceptance we looked at last class. Today we will be looking at few more. The 7th point says it must be absolute and unconditional. That means whenever an offeree is going to accept the offer, he should not add any added conditions or any kind of alterations to be made in the offer. Only if these conditions are altered or changed, then I am going to accept the offer. That should not be his reply. Okay? Any alteration or any kind of small variations, however small, of the offer will make the acceptance invalid. So, if the person who is going to accept the offer is going to make any kind of minor changes, then will that acceptance be valid in the eyes of law? No, it is invalid in the eyes of law. Let's look at this case. It's Neale versus Meerit. So, Meerit is a person who is going to offer his land for sale to Mr. Neale at rupees 280 pounds. Remember, Meerit is a person who is the seller of the land. He owns the land. He wants to sell it to Neale at rupees or at 280 pounds. Neale accepted and enclosed 80 pounds with a promise to pay the balance by monthly installments of 50 pounds each. Now just read that line again. The first 2 words says Neale accepted. That means he is accepting the offer as it is laid down by Mr. Meerit. What is the offer? Selling the land for 280 pounds. But the next sentence, can you see the next word? Accepted and enclosed. Did he enclose 280 pounds or 80 pounds? 80 pounds. So basically he is altering the offer there. Okay, he is making certain changes and he himself is adding a promise to the offer that he is promising to pay the remaining balance of 200 pounds in a monthly installment. Now this is called as invalid acceptance. Is that clear? So it was held that there is no contract between Neale versus Meerit as the acceptance was not absolute. Was not absolute means however Meerit offered for the 280 pounds, did he accept it in the same terms? No. He simply said he accepted, but then he added his own conditions or his own alterations to the offer. He enclosed 80 pounds and promised to pay the remaining in the 50 pounds in equal monthly installments, which was not given in the original offer. So, is altering the offer or making certain changes in the original offer and then giving his acceptance, which in the eyes of law is termed as invalid acceptance. Is that clear? This is the case versus Neale versus Meerit. Let's also look at another case, Jordon versus Norton. Now here is the case that Jordon writes to Norton that he wants to buy his horse, stating that the horse sound should be good and quiet in one harness. Let me first say what is harness. If you can see the picture at the bottom, the person holding the 2 sides or the ropes of the horse that is tied to its mouth, correct? So those are called as harness. Understand? So it is on both the sides, on the right and on the left. So what Jordon writes to Norton is that with one harness, so one side of to the right side, if I am going to pull the harness, the horse must be quiet. Okay, otherwise it should make sound, but when I am going to pull it on the one side, on the right side, it must be quiet. Okay, so Jordon is writing to Norton that he wants to buy his horse and he is stating that this is the condition. Okay, it must sound good, and also with one harness the horse must remain quiet. Norton replied back to Jordon saying, I accept the offer. Remember, he is also accepting the offer and wrote back that the horse sound is good. The sound of the horse is good, but it will be quiet in double harness. So he is saying that only by pulling one side of the harness, the horse is not going to remain quiet. Instead, you need to do both, right and the left. You need to pull it on the both the sides for the horse to be quiet. Okay. First, he is telling, he is accepting to the terms and condition laid down by Jordon, but then he himself is adding an alteration, or he is adding a minor changes to the offer and then giving his acceptance. So it was held that it is not a valid acceptance, as Norton's reply was a counter offer and acceptance was not absolute. Why is it saying counter offer? Because he is telling it's not by one harness but by two harness. A counter offer can be any kind of minor changes in the offer. It does not have to be a great change, but even a minor change will result called counter offer. Now we already have looked in the essentials of a valid contract. A counter offer is not a valid offer because basically a counter offer is a rejection of original offer. Hope you recall that essentials of a valid offer. Counter offer is a rejection of original offer. You are giving back another offer with alterations or with some kind of minor changes. Is that clear? That is called as a counter offer. Now this case versus Jordon versus Norton was termed as no contract, or the acceptance given was invalid. What is the reason? Norton accepted the offer, but he added his own conditions or changes to the acceptance, which the law says is invalid. Hope you have understood the point number 7. It must be, acceptance must be absolute and unconditional. In this case, Neale versus Meerit, he also accepted the offer of Meerit, but then he enclosed or he made his own alterations to the offer, which was invalid in the eyes of law. In the case of Jordon versus Norton, even Norton accepted the offer but made his own alterations or changes to the original offer, and therefore both these cases was termed as invalid acceptance. Is that clear? Point number 8. A mental acceptance is ineffectual. No acceptance has made by mind without expression or implied. Such acceptance is not valid or not effective. So here I am talking about a mental acceptance. So a person has offered you to buy his land or to buy a computer, etc. But then you are not signifying your assent or your agreement or your acceptance to him in any manner. Either orally, we always learned, right, an offer must be expressed, or a acceptance must be expressed through words or implied. Okay, either by words you are telling I accept, or either by your behavior or conduct you are signifying to the other person that you accept the offer. But here the condition is a mental acceptance. So basically in your mind you are just agreeing to it, not conveying this agreement or this acceptance to the offerer. In such case the acceptance is not valid. Is that clear? Unless and until you are going to communicate it to the offerer, the acceptance is not at all valid. Either you have to express it orally, or you have to express it by your conduct or by your behavior. Express means I am going to orally tell him, or I am going to write a statement, I agree to your offer on so and so contract, etc. If it's implied, by behaving according to the conditions of the offer, I am going to convey my acceptance. If we can look at the case of Carlyle versus Carbolic Smoke Ball Company, she didn't have to, did she orally tell the company that she is accepting the offer? No, she just performed the conditions of the offer. You got that point? She just performed it by action, by conduct, by behavior. So it was termed as acceptance in the court of law. But a mental acceptance, that is just in your mind, only you know that you accepted the offer, but you have not communicated it to the offerer. In such cases, the acceptance is invalid or not effected. Is that clear? Number 9, acceptance can be made for the renewal of rejected offers. The acceptor can give his acceptance for the rejected offer if the same did reviewed. Now here what I am talking about is, let's say same Mr. A is offering to sell his house for rupees 10 lakh to Mr. B. This is a offer. Mr. B has rejected the offer. Okay, or let's say has made certain changes, as in to say it's a counter offer. I would not like to purchase it at 10 lakh, but I am ready to purchase it at 9 lakh. Is that clear? So the offer was rejected and then it was renewed. So Mr. A also, after the bargaining is done, he also settles down to the price of rupees 9 lakh. So he is reviewing or renewing the rejected offer. So he agrees again to say, yes, I am ready to sell my house at rupees 9 lakh to Mr. B. Is that clear? Now in this case, Mr. B is going to accept the rejected offer because it is being renewed or it's being reviewed. Is that clear? So in this case, acceptance can be made for the renewal of rejected offer. Let me just repeat the example. A offered to sell his house for rupees 10 lakh to B. Now B was not ready to buy the house at rupees 10 lakh. He told, my price to buy the house is only rupees 9 lakh. So basically he is not accepting to the terms of A, he is rejecting the offer and giving his terms and conditions, for which A was ready to renew the offer or A was ready to review the offer. So A, after the bargaining, he says, I am ready to sell the house for rupees 9 lakh to B. So B is going to say, then I am going to accept the offer. So basically it was a rejected offer and then A is renewing it or reviewing the offer and then B accepts the offer. So in this case, the acceptance is a valid acceptance. Is that clear? The 10th point says, the acceptor must be aware of the proposal at the time of the offer. When an acceptor is not aware of an existence of an offer and conveys his acceptance, then there is no valid contract. So here the condition basically says that whoever is going to accept the offer, if he is not even aware of that such an offer exists and then he is giving in his acceptance, then in the eyes of law it is not termed as acceptance at all. The offerer and the offeree must be aware of the offer. Only when you are aware of such offer exists, only then can you give acceptance, correct? When you do not know that the offer is available and then you are giving acceptance, it's not termed as a valid acceptance. We looked at the case long before, Lalman Shukla versus Gauri Dutt. If you can remember that, Gauri Dutt was a servant of Lalman Shukla, where he is going to find his missing nephew. Meanwhile, he is going to put up an ad, whoever is going to find my missing nephew, I promise to pay him 100 pounds basically. Okay. Now here what happens, the servant brings back the nephew back home, but then he does not know or he was not aware that there was an ad or an advertisement put up for the missing person. If whoever finds it will be rewarded rupees 100 pounds. Is that clear? So he was unaware and still he filed a case against his owner in the court of law. What did the judge say that time? When the advertisement was made, you were not aware of the advertisement or you were not aware of the offer. After completing your duty or after finding the missing person, you found out that there was an offer and then you are trying to get the reward, which is not valid in the eyes of law. Is that clear? Otherwise also, as a servant, it was his duty to find the owner's missing nephew. It is not a for the prize or for a reward he has to do. He is already being paid salary by his owner, so it's his duty to perform whatever his owner is asking him to do. Is that clear? So this case applies to this condition as well. The acceptor must be aware. If he is not aware, then the acceptance is invalid. If he was aware, then the acceptance could have been valid acceptance. Is that clear? So today we have studied 4 different conditions. First one, it must be absolute and unconditional. Both these cases we looked at made minor changes in the original offer, where the court of law says it is invalid acceptance if it is not absolute and unconditional. We looked at that a mental acceptance is ineffectual. That means just by agreeing in your mindset, and if you are not conveying, it is not a valid acceptance. Either you have to express through words or by your conduct or behavior. Acceptance can be made for the renewal of rejected offer. So original offer is rejected, you can renew it, and if the person accepts it again, then it's still valid in the eyes of law. The acceptor must be aware of the proposal at the time of the offer. Only when the acceptor is aware of the offer, the acceptance is valid in the eyes of law.